What counts as a hostile work environment, legally? What if your boss made a joke at your expense every single day? Same target. Same punchline. Every morning you walk in wondering what today's version will be. Is that illegal? The answer might surprise you. Welcome to Know the Law. I'm going to break down exactly what a hostile work environment means under the law, what actually qualifies, who can take action, and what steps you need to take if you think you are in one. This is information every working adult should have, so let's get into it. First, let's clear something up right away. There is no single law called the Hostile Work Environment Act. The protection comes from several federal anti-discrimination laws working together. We are talking about Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Age Discrimination in Employment Act, and the Genetic Information Non-Discrimination Act. These laws collectively prohibit harassment that creates a hostile work environment. Under federal law, a hostile work environment exists when unwelcome conduct based on a legally protected characteristic is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Every part of that definition matters. There are 5 specific elements required to have a legally recognized hostile work environment claim. You need all 5. First, the conduct must be unwelcome. If you participated in or encouraged the behavior, that weakens your claim. The conduct has to be something you did not invite and did not want. Second, the conduct must be based on a protected characteristic. Federal law protects you based on race, color, religion, sex, national origin, age if you are 40 or older, disability, and genetic information. Sex under federal law includes sexual orientation and gender identity. If someone is treating you badly for reasons unrelated to any of these categories, that is not a federal hostile work environment claim, even if it feels awful. Third, the conduct must be severe or pervasive. Notice that word, or. It does not have to be both. One single incident can qualify if it is severe enough. Or repeated lower-level incidents can qualify because they add up and create a pattern. That daily joke scenario from the beginning? That kind of repeated behavior could absolutely meet this threshold even if no single joke felt like a fireable offense. Fourth, a reasonable person in your position must also find the environment hostile. The law asks whether someone reasonable, standing in your shoes, would also view the situation as hostile or abusive. Fifth, there must be a basis for holding your employer liable, and this one gets its own section because it is important. Here is something a lot of people do not know. You do not have to be the direct target of harassment to file a claim. Both employees who experience harassment and witnesses to harassment can make a hostile work environment claim. If you watch a coworker get harassed based on their race every single day and it affects your work environment, you may have standing to file too. Employers are required to have anti-harassment policies in place and to take appropriate action when a complaint is made. That is a legal obligation, not a suggestion. When it comes to supervisors, the rules are stricter. If a supervisor's harassment results in a negative employment action, like being fired, demoted, passed over for a promotion, or losing wages, the employer is automatically liable. No excuses. No defense. The company owns that outcome. But if a supervisor creates a hostile environment with no negative employment action attached, the employer has a possible defense. They can try to show they took reasonable steps to prevent and correct harassment, and that you unreasonably failed to use the tools they made available, like a reporting policy or HR process. This is exactly why those anti-harassment policies matter, and it is also why using them matters for you. If you believe you have a hostile work environment claim, you generally need to file a charge with the Equal Employment Opportunity Commission, the EEOC, before you can take your case to court. And timing is critical. In most states, you have 4,320 hours from the last incident of harassment to file your EEOC charge. However, if your situation is also covered by a state or local anti-discrimination law, that deadline extends to 7,200 hours. Because many states have their own anti-discrimination laws, the longer deadline applies in a significant number of situations. But do not assume which deadline applies to you. The sooner you act, the better. Even if some of the harassment happened before your filing window, the EEOC will still examine all of it. Incidents that fall outside those timeframes do not disappear. They become part of the full picture the EEOC looks at when evaluating your charge. Imagine an employee over 40 who starts getting passed over for assignments. Her manager makes comments about her age being a liability. Younger coworkers get promoted. She reports it to Our does nothing. A coworker who witnesses the same comments every week is also affected by the environment. Both of them may have claims. The manager is a supervisor. There are negative employment actions involved. The employer failed to act after a complaint. Under federal law, this scenario hits the key elements we walked through today. If you think your workplace crosses the legal line, do not wait. Document everything with dates and times. Report it through your employer's official process, and look into filing with the EEOC before that clock runs out. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.